Attend the court, please. The Honorable Attorney for the State of New Mexico.
Good afternoon. You may be seated. Thank you. Good afternoon. We're here on the matter of an inquiry concerning a judge, S-1-SC-40665. We'll begin with a petitioner, judicial standards. You have 12 minutes, 8 minutes rebuttal. You may proceed.
Mr. Chief Justice, Justices, may it please the court. We are here because the commission is requesting that this court adopt its findings and its recommendation to issue an order permanently removing respondent from judicial office. The commission unanimously agreed there was clear and convincing evidence that respondent committed willful misconduct in a couple different ways. Number one, she used her judicial login credentials to create a document that falsely claimed that that document, a summons, was created, prepared, printed, and served by the Otero County Magistrate Court. It was not. It was a document that respondent was able to create and print out and serve on the defendant in her own personal case due to the fact that she is a judge and had judicial login credentials. In addition,
is the issue here the creation of the document or the access that she generally, or is it both?
Mr. Chief Justice, Justice Bacon, I believe it is both. She was specifically told by Jason Clack, who was an attorney with the Administrative Office of the Courts at the time. Now he's with the Department of Information Technology. She was told at the time, that is, respondent was told at the time, do not use your judicial credentials to deal with your personal case.
So get outside access.
Public access account.
So you think it's your assertion, or I should say that the hearing commission's assertion is that it's both?
Yes, Justice Bacon.
Thank you.
That is correct. In addition, when confronted by Judge Mitchell, the Roosevelt County Magistrate Court judge who was dealing with her respondent's personal case, when he confronted her with that document and said, did you create this document? Findings of fact 132, respondent said, I did not create that summons. Findings of fact 133, that must have been clerk error. Both of those was respondent being dishonest. Judges are not allowed to be dishonest. When judges are dishonest and they lack credibility, this court has determined and mandated that those judges are removed. I'll bring up two cases in particular. The first case is the Rodella case. The Rodella case is 2008 NMSC 050. In paragraph 36, it deals with two categories of judges. There's a category of judge where through their misconduct, they could get training, they could get mentoring, and their conduct can be changed. However, there's a second category, again, dealing with paragraph 36 in that Rodella case, where judges lack credibility. Now, in that 36th paragraph, they quote the Griego case dealt with in that same year, 2008, and MSC 020. And the quote from the Griego case, paraphrased, is, when a judge lacks credibility, they are not allowed to judge the credibility of the litigants in front of them. Judges are held to a higher standard. It says so in the preamble to the Code of Judicial Conduct. The last sentence in the preamble to the Code of Judicial Conduct, that's 21001, says the following rules, the rules of the Code of Judicial Conduct, are there to assist judges in maintaining the highest standards, not a regular standard, not a high standard. The quote is, maintaining the highest standards. That's repeated in Rule 21-102. That rule has to do with judges shall not have impropriety nor the appearance of impropriety. In committee commentary number 2, it again says that judges have public scrutiny that would be burdensome for the regular people to have. But unfortunately, they're in that situation. If you're a judge, you cannot be dishonest. That's from the Rodella
What if
case.
you're being dishonest about something that's not material to anything? Same rule? You're saying if you're dishonest about anything, you're not qualified to be a judge. You're arguing a per se rule, and I'm not seeing that in the code.
Mr. Chief Justice, Justice V. Hill, according to case law, the Griego case and the Rodella case, they specifically talk about judges lacking credibility, being dishonest. In addition, I would
That's a
add,
blanket rule.
according to the case law, Justice V. Hill, it is a blanket rule. A judge cannot lack credibility and then judge the credibility of the litigants in front of them. That's based on the 2008 cases. In addition, I would argue that it doesn't matter whether they are on the bench or whether it's in their personal lives. Again,
So if I lie about my size of my shoes, I'm not qualified to be a judge. That's what you're saying.
I'm sorry for interrupting. Mr. Chief Justice, Justice V. Hill, the rules are clear that judges are held to a higher standard.
I understand that. I'm just asking a simple question of what you're arguing. Are you arguing that being not credible about anything disqualifies you from being a judge?
Justice V. Hill, based on the case law, that is our interpretation of the case law. If a judge lacks credibility, they cannot be a judge. They are held to a higher standard, and it doesn't matter if it's in their personal life, in their personal conduct, or if they're on the bench. That again.
So there's no, I think going to the senior justice's point, so you're saying there's no materiality necessary to it. So if I go to the doctor's office and I fudge my weight, I can't be a judge because my credibility is shot. It seems to be a fairly extreme position because the only person I'm hurting is myself, and so who cares?
Mr. Chief Justice and Justice Bacon, luckily in this particular case, we're not dealing with something like that. We're dealing with a situation where it did affect other people. Now,
But so I just want to be, I think what we're suggesting is we need to be very careful about the breadth of the rule that you're telling us is so, because the context of Rodella and Griego are going to be tethered to our code. It's not going to be, I ate 2 Girl Scout cookies instead of 1 Girl Scout cookie. And so I think that's the senior justice's point, is we got to be careful about the breadth of anything that we say about this, because if we're going to say fudging on your weight means you can't be a judge, I'm guessing that none of us on this bench can be judges, because nobody's honest. Come on, nobody's honest about it.
Mr. Chief Justice, Justice Bacon, I agree with you. Luckily, in this situation, that's not what we're doing.
But I think that's where the
Yes.
senior justice is pressing you, is that we've got to be careful about the breadth of anything that we say.
Understood, Justice Bacon. And in this particular case, we're dealing with a judge who used her judicial credentials to print out this document, have it served on a defendant, and then was dishonest when confronted by Judge Mitchell with that document. She also didn't follow the instructions given to her by those that she went to. She was deceptive not only to Judge Mitchell, but was deceptive to Judge Murphy also. She went to Chief District Court Judge Murphy in the 7th Judicial District and let Judge Murphy know what was happening in the case. And that is, hey, I have a quote unquote squatter living in my house. I'm going to be dealing with this case. Judge Murphy gave some great advice. Let your case play out like any other litigant. The respondent did not do that. When talking to Jason Clack and telling Mr. Clack about the situation, Mr. Clack said, get a public access account to Odyssey. You don't want to create any documents because your name is going to be listed on those documents. He failed to follow that advice as well. So she was deceptive to those two people. She was also deceptive to the defendant in the case. The defendant, this homeless person who came out from Maryland, didn't have any friends around, didn't have a car, but was so disturbed by the document that he received the wrong summons. The summons was for a regular civil case, and it said, if you don't do certain things within 20 days, you may be found in default. And that so troubled him that he wound up back at the magistrate court and talked to them about the document. She was dishonest to him as well. Also, respondent was dishonest to the commission in two places. In the findings of fact 163, the commission found that the witnesses were credible except respondent. That was findings of fact 163. Conclusions of law 28. The respondent was not credible and failed to accept accountability for her actions. In addition, not just being deceitful to those people, there was a pattern of not correcting this misconduct. She could have corrected it at any point. The respondent could have printed the document out and seen that it was in error because her name was down where the clerk was supposed to be. The testimony that she gave was that she didn't look at the document. So that was the first time she could have corrected the error. The second time she could have corrected the error was when she wanted it served. Before you have a paper served on somebody, you may want to look at the document just to make sure that all the information is correct. It's coming from the correct court. She didn't even look at the document at that time prior to having it served on the defendant in her personal case. She could have looked at, the testimony was that she was looking at the case daily to see if the defendant was served in the case. As soon as the defendant got the document, he took it into the magistrate, Carroll County, and it was filed in the case. She could have looked at that filing, looked at the document, saw that it was incorrect, saw that her name was down as the clerk, and could have let somebody know about it. She did not take that opportunity to correct her error. Finally, she could have corrected the error when confronted by Judge Mitchell. Again, findings of fact 132, I did not create the summons. Findings of fact 133, it must have been a clerk's error. Both of those deceived Judge Mitchell, deceived the court, and we again ask that respondent be permanently removed from judicial office.
What does that mean? What do you mean by permanently removed?
Mr. Chief Justice, Justice Vigil, what that means is that not only should she be taken off of the bench right now, which she already has, she's temporarily suspended at this time. Not only should she be removed right now, she should not have the opportunity to go back. And again, I would rely on the Rodella and the Griego cases to assist me in that recommendation.
Thank you, counsel. Response, Mr. Candy, 20 minutes.
Mr. Chief Justice, Justices, may it please the court. My name is Paul Kennedy, and I represent Judge Griffin, who's sitting with me at council table. It's important for this court to realize that Judge Griffin was charged with two items of misconduct in the charging document. Number one, she was charged with creating and printing a civil summons in her personal case that fraudulently reflected the document was created, filed, and served by the Otero County Magistrate Court. With my emphasis on fraudulent. Secondly, she was charged with failing to be truthful to Judge Mitchell. Not charged with anything else, even though the findings are all over the map and include things that aren't included in counts 1 and 2. What the commission never grappled with, and it never answered my query in this regard, and never sustained my objections. But they never explained why this is a fraudulent act on the part of Judge Griffin if the document that was allegedly fraudulently created had no legal efficacy, meant nothing. meant nothing in the litigation, meant nothing anywhere else, meant absolutely zero. As this court is by now aware, there were 2 eviction cases filed by Judge Griffin. 191 was filed in early May. 222 was filed in early June. Judge Griffin was just anxious to get this squatter out of her house and was afraid that the case was not moving forward because of serial recusals by other magistrates in the area, and thought that if she asked for a jury, that would take it out of, that would solve the recusal issue. It doesn't, but she didn't realize that. So she filed the second case so that she could ask for a jury, did that, and being 5 hours away from Alamogordo, where the packet was, the filed second lawsuit with the summons was at her son's house. She's 5 hours away, and she said to herself, I'm gonna just fax this to a process server in Alamogordo and have it served. So her intent in going into the Odyssey system was merely to print out the lawsuit and be able to fax it over to the process server and get the case moving.
Kennedy, with that recitation, though, you're asking us to reweigh the facts where the hearing panel found your client not credible. So how do I?
They did, but this is not appellate review. As the rules state, you can do anything. And there's one famous former justice.
Yeah, but in this, I recognize that, but we are not going to have a trial here today.
No,
I am not going to assess your client's credibility.
no.
And at a certain point, I have to trust the finder of fact and their statement about credibility, and that.
And my argument,
Thing to do here.
my argument is the finder of fact never grappled with this issue. They never addressed this issue.
I get that you're saying that you're questioning the issue supporting fraud, but your client's explanation of, oops, it was an accident, they didn't believe her.
They
And
didn't.
I don't think I can look underneath the hood of their belief of her, setting aside the question of have they met the threshold for fraud. They didn't believe her. And you're asking us to believe her.
Well, I'm asking you, they didn't believe her, but what I'm saying is, what difference does it make? The document that was printed, and we allege inadvertently, meant nothing. She gained no advantage in the litigation, which the commission late decided, well, she did gain some advantage and tried to make something up. There was no advantage in the litigation. There's no disadvantage to the adverse party.
Then why did she lie to Judge Mitchell?
She didn't lie to Judge Mitchell. She didn't know what Judge Mitchell was talking about. Judge Mitchell admitted.
Again, you're asking us to reassess the facts.
Well, I'm asking you to sit as the Supreme Court in a judicial standards matter, not in an appellate matter. And you have a lot more latitude to do what's fair and equitable and just in a case like this than you would in a regular appellate court.
We tend to still defer to the fact finder,
Well,
which is the Standards Commission.
and I guess what I'm saying is, if you want to defer to the fact finder, I'm arguing to you that the fact finder never addressed the issue of the materiality of this document. And
Why is that necessary? In other words, if you replace the word misrepresented or fraudulently, that misrepresented, the document was that incorrectly or misrepresented that the document was created, filed, and served by the Ventura County Magistrate Court. It doesn't look to me like they were using the word fraudulently there in a strictly legal sense. Tell me what I'm missing.
Well, I'm a lawyer. I was representing the judge on this case, and when I read it, I interpret it fraudulently as I would in any other legal
She's not
document.
accused of committing a crime of fraud.
No, she's accused of civil fraud.
She's accused of creating to create and print a civil summons in her personal case that fraudulently reflected, that incorrectly reflected.
But the
And mis-
fraudulent,
Go ahead, I'm sorry.
the fraudulent means that there had to have been a dishonest end to her motivation. In other words, what's the fraud? You can create a document for whatever reason. We claim it was inadvertent. They claim it was intentional.
Well,
But-
they
but-
did find that she did it with the intention to gain an advantage in the litigation and advance it more quickly.
See, that's what I quibble with the commission about, Justice. That's just not true.
But that's what they found. So how do we get
There's no
around
basis for
the
that.
fact?
There's no basis for that.
Why is there no basis?
This,
She said, I was trying to get this done more quickly because I needed my friend to move in there.
there's nothing wrong with that. You just want litigation to move quickly.
But there's advantage and gain to that happening.
But not an dishonest or unlawful advantage. I just want the case to move forward. She asked for a jury. That's going to slow it down.
So
it
a
seems to me.
judge can monkey around with whatever they want as long as it's not illegal?
The judge can't monkey around with anything, but if the commission says this judge monkeyed around with that document, to what end? They never, what did it mean? It meant
How
nothing.
does that, I mean, when she was charged with violations of 102, which is acting in a manner that doesn't promote, that contradicts promoting public confidence. She was charged with acting in a manner that does not fairly and impartially uphold the values of a judge under 202. Even if we don't ever get to maybe she didn't commit fraud, the fact that they found whether that was what she intended or not. The findings were that she lied to the judge, she lied to the Standards Commission, that there were several misrepresentations or lies. How do we get past, in particular, those two provisions that she's accused of violating?
Well, you get past them by finding that she obviously had no intent to do anything dishonest or fraudulent.
But we can't do that when the commission said she intended it and she was trying to gain an advantage by moving things quickly.
I respectfully disagree. You're the Supreme Court. You can do that. Can do that. And the rules particularly say this court can impose any sanction, whether lesser or greater than what the commission recommends. It's entirely in the court's hands. Nobody's going to review your decision
So why should we impose a lesser sanction here?
because what she did had no legal effect on the litigation.
Once again, let's substitute the phrase that she created and printed a civil summons in her personal case that misrepresented. The document was created, filed, and served by the Otero County Magistrate Court.
For what purpose?
The charge is not that she did it for a purpose. The charge is that she created this document which misrepresented that it was created by the Otero County Magistrate Court. It was not. It was created by her.
Right.
And it went out into the public as if it was created by the Magistrate Court.
And you even heard counsel just admit she never read it. She printed it. It autocopied.
Doesn't matter. She created it.
Well, she didn't know she created it. She printed it. She hit the
Okay.
print button.
Back you up a step from even that. She was clearly told, if we accept testimony of a whole bunch of people as true, she was clearly told, stay out of Odyssey. You're gonna, because it's gonna lead you down this path. So I will assume with you, it was the creation of the document might have been a mistake. But she used her judicial position and power to do something nobody else can do, contra what the chief judge told her, what Jason Clack told her.
I disagree. The chief judge told her that he could use her judicial access to get in and look at the case. And she said, just don't change anything.
And why print anything? Why do anything? Clack told her, don't do it. You can only deal with your case
With all due respect,
with using the public access part of
with
this.
all due respect, the conversations with Jason Clack were in July and August, well after this June 2nd incident. And that was glossed over again by the commission and its counsel. But the conversation with Jason Clack was not before she went in on June 2nd and hit the print button. And Judge Murphy told her, you can go in there, just don't change anything.
Is it your client's position she did nothing wrong at all? I mean, that's what I'm hearing.
No, I admit, it's a series of, it's a series of mistakes all along the way and
Blaming
misunderstanding.
the clerk's office is a
But she-
pretty darn big mistake.
But she didn't blame the clerk's office. She said to Judge Mitchell, I don't know what that is, but must have come from the clerk's office. She had no idea her name was on that document.
But again, her testimony was found to be hogwash.
I don't remember that word.
But I mean, you get my point. And I don't mean to make light of any of this.
I'm sorry, I'm sure.
Important, but I feel like you're asserting to us she did nothing wrong.
Well,
And
I'm asserting she did nothing consciously dishonest. Nothing blatantly consciously dishonest. There was no reason to create another summons, and both summonses were served on the defendant litigation. It's not like she was hiding anything or trying to change the meaning of the lawsuit or anything. That's just the way it happened. I have about 7 minutes left. Would the court like to hear from Judge Griffin? He would like to.
Up to you.
yeah, if you'd like to speak, certainly. I shouldn't speak for the chief, sorry. Ooh.
Mr. Kenny. Because any factual testimony, I'm going to need to swear your client in. That's okay. Okay. Raise your right hand. Do you solemnly swear affirm or appellate of law testimony you'll give in the court will be the truth, the whole truth, nothing but the truth?
I do.
Make this.
Thank you for giving me the opportunity to address this court today. I've prepared my statement so as not to ramble and waste the court's time. I'm obviously very nervous, so I'm just going to read, if you all don't mind. I've always believed in the system. When the Judicial Standards Commission announced their decision to request my removal, I could have taken the easy way out and resigned my position. That would have been a betrayal to all those who elected me, so I knew that the easy way was not an option. With that being said, this is why I'm here today. I made a mistake, and yes, Justice Bacon, I did. I recognize that I did something wrong. I made a mistake, for which I am very embarrassed, and for which I apologize to the court. I know you have all reviewed the case, along with the accompanying documentation and testimony. When Judge Mitchell asked me if I had created a document, I said no. That was my answer. It was just no. I believed that. I thought that I had only printed what the Otero County Magistrate Court had entered into the system. That's what I thought. But the system self-populated. Everything that was entered on the document, including my name, because I was logged in with my own credentials. I did not add, subtract, or change anything on the document. I just printed it. I was a new judge and was not familiar with, nor had I learned to navigate the Odyssey system well enough. I had been printing documents out of the Tier C court because they had asked me to. I had been covering for Tier C a lot, And they were short-staffed and didn't have time to print the documents and get them to me. So I had been printing documents at the request of the Sierra County Magistrate Court. I didn't know that when you went into the forms, that the system self-populates. I just didn't know that. The prosecutor would have you believe that I'm some kind of malicious monster. But as God is my witness, I am not that person. Unfortunately, when I appeared before the Judicial Standards Commission, I was so intimidated that it was easy to make me look incompetent and bad. I could barely remember my name. I'm not an attorney, so I was still in the process of learning a new system. When I attended the new magistrate's training, we were told that by the end of the week, we would feel like we had been drinking from a fire hydrant. That lasted for a full year. You are all attorneys, so you would not make that mistake. However, most new magistrates are just your everyday citizen trying to do a fair and honest job, thus the People's Court. That was me. I have a passion for justice, and I would never break the rules. I was raised in a military home and was taught to always follow the rules. My dad was a career pilot, flight instructor, and assigned 4 base commands. During his career, he always taught me, if you want people to respect you, you first show respect. That has been a lifelong lesson that is branded in my brain. My whole life, I've tried to help people because I care. I would never, ever deliberately mislead, harm, or bully another human being. It doesn't matter who they are or what their situation, it's just not who I am. I live by a motto, I shall pass this way but once. If there's any good that I can do, let me do it now, or I shall never pass this way again. I ran for this position because I felt that I could make a difference. I saw all the problems that the courts were having to deal with, especially with mental health issues, and hoped for a light at the end of the tunnel at some point. I volunteer at every opportunity to contribute to my community as a first responder with EMS and fire, as a 4-H leader with the Roadrunner Food Bank home delivery for shut-ins. I also served on the New Mexico Crime Victims Reparation Commission for almost 14 years. I chaired the New Mexico County's Criminal Justice Reform Committee and attended workshops by the New Mexico Sentencing Commission. Everyone knew that I was having trouble with this man who had taken possession of my house without my knowledge. I spoke of it many times with friends, family, and coworkers. When I went to see Jason Clack, after I received notice of the NMJSC complaints, it was to ask him what to do next.
Ms. Griffin, your time has expired. I'll ask that it's okay if you can just wrap up. Okay, I have to be, we're going to
Okay,
equal
all
time
right.
to both sides. I need to be fair here. So just wrap up very
Okay,
quickly, please.
I'm actually glad that Mr. Braithwaite filed his answer to my complaint within 9 days of the filing. He didn't answer the first complaint. I was always polite and nice to Mr. Braithwaite. If you decide to order an alternative discipline, the recently retired judge, after 20 years on the bench, has offered to touch base with me on a daily basis and give me guidance if needed. He is currently serving as interim during my suspension. If you decide to remove me, I ask that you do it because I made a mistake and not because I intentionally tried to hurt or bully another human being. I'm sorry I ran over the time. Thank you very much.
Thank you, Ms. Griffin. Thank you. Rebuttal, 8 minutes.
Beg your pardon?
We'll hear rebuttal for 8
Oh.
minutes. Thank you, Ms. Griffin.
Thank you, Mr. Chief Justice, Justices. I want to start with, I appreciate the justices bringing up the fact that fraudulent does not mean we are accusing a respondent of committing a criminal act. That is for a district attorney's office to determine. The allegation was that the document that was created by respondent had fraudulent information in it that is fake information, false information. I appreciate the justices.
Is there any other requirement of fraud, reliance? Mr. Simply, it's hard to tell. I think the debate is if it's a fraud or false. There's more to fraud than simply being false. What other elements other than being incorrect?
Mr. Chief Justice, we were using that word only to indicate that it had fake, false, phony information in that document.
With intent or just that?
Just, Mr. Chief Justice, just that it had fake, phony, false information in
That wasn't the charge. The charge is that the document was created, filed, and served by the Otero County Magistrate Court.
That's
the charge.
Mr. Chief Justice, Justice V. Hill, that is correct. The fake nature of that document was that it was filed and served by Otero County Magistrate Court, which is incorrect. That is false information. It was not filed and served by them. It was served by respondent. That's why it was fake.
The document reflected that it was served by the clerk.
Mr. Chief Justice, Justice V. Hill, that is correct. When the respondent generated that document, it was file stamped at the upper right-hand corner, Exhibit 26. You'll see Exhibit 26 in your materials. In the upper right-hand corner, it was file stamped the date that responded.
That wasn't my question. My question, does the document say it was served by the Otero County Magistrate Court?
Mr. Chief
That's
Justice,
the charge.
Justice V. Hill, unfortunately, I don't know the answer to that question because I don't have that document in front of me. It's not a document that I've recently looked at.
Isn't it that it showed that the Otero County clerk issued the summons and that a process server was engaged to effectuate service of process by the judge?
Mr. Chief Justice, Justice Bacon, that's exactly right. Now refreshing my recollection with your comments, Justice Bacon, that is correct. The clerk is certifying that that is going to be served on the defendant. That clerk is listed as a respondent's name down there. So yes, we stand by the fact that that was fake, phony, false information. Now, finally, the respondent says, hey, this was just a mistake, but that is contrary to what the commission found. The commission found that the respondent committed willful misconduct. Well, willful misconduct, according to the Locatelli case, is wrong or improper conduct by a judge in his or her official capacity, which is intentionally, knowingly, and generally in bad faith. That's what the commission found already, was that it was intentional.
Was there any testimony that she was told if you print a document, it's going to come out that with your name on it, that you were the clerk?
Mr.
Is there any
Chief
testimony on that?
Mr. Chief Justice, Justice V. Hill, I don't remember exactly testimony having to do with that. When respondent's counsel said, well, there was evidence, he's actually arguing the evidence. There was evidence that respondent put in some emails that she had with Jason Clack after the fact, after the document. However, Jason Clack's testimony was that they had a conversation prior. So he's actually arguing the evidence, and I'm asking this court not to consider that argument. And when respondent's attorney says something that they've never grappled with was the fact that the document had no legal effect. Well, that's not true at all. He raised that in his closing arguments on August 7th, 2024. The commission dealt with that problem then. In addition, on November 13th, 2024, Respondents' Counsel put in an objection to the findings of facts that you all have before you. In that objection, in paragraph 4, he said the June 21st, 2023 summons was of no legal efficacy. Paragraph 5, he says, the commission has consistently failed to explain what the advantage or leverage was to the respondent. So this whole thought about the commission has never considered the fact that the document had no legal efficacy. That is an incorrect statement. They considered it twice already. That
Isn't, I think, in fairness to Mr. Kennedy, I think what he's saying is it's not reflected in the findings and conclusions what the legal efficacy is.
Mr. Chief Justice, Justice Bacon, it may not be reflected in there, but what is reflected is that it is willful misconduct. That is acts that are done intentionally, knowingly, and generally in bad faith. So the respondent took the stand and she said, hey, this was a mistake. I didn't know what Judge Mitchell was asking for me dealing with the second allegation. I didn't know what Judge Mitchell was asking for me. 132 says that she told, finding of fact 132 says, paraphrased, that she said, I did not create a summons. Now, in reality, if she didn't know what was being asked of her, she could have said, Judge Mitchell, I'm sorry, I don't understand the question. Judge Mitchell, I'm sorry, I don't think I created anything. I know I printed out a document, but I'm not sure I created anything. There was no question. That was a factual statement. 133, again, it must have been a clerical error. It must have been a clerk's error. That is not a question that she had. That's a finding of fact of an affirmative statement that she made. So the whole argument that it was just a mistake, that has been dealt with by the commission, and the commission found that there was willful misconduct. As far as she didn't gain anything from it, that is, the respondent didn't gain anything from it. Well, she had access to a system that only she and the clerks had. Judicial login credentials are given only to judges and the clerks. So she had access to this system that in fact helped the case move forward. At the time, the case was stale, and remember what was happening. There was somebody squatting in her residence. She needed to get Mr. Harper down from Farmington into that house, and finally, the judges were recusing. That creates the intent that we're seeing here. It was no mistake. It was willful misconduct, and we're asking for her permanent removal from judicial office.
Thank you, counsel. In the matter of S-1-SC-40665, court's going to take a recess while the parties remain in the courtroom. If we're not able to announce the decision, we'll advise the clerk. Clerk will advise you. We ask that you stay in the courtroom. We're very close. If the decision comes at a later date, the matter will be deemed submitted. But for now, the court is in recess.
And for it, please.
I think you may be seated. Back on the record, S-1-SC-40665 in the inquiry concerning a judge, 2:45 PM, April 24, 2025. Respondent is in the courtroom, counsel is in the courtroom. Ms. Griffin, you'll stand, please. Court appreciates the arguments today in the papers, the argument presented in the papers and oral argument today. The court having reviewed the pleadings, being otherwise advised, finds and concludes as follows. Although the court finds there is sufficient evidence to support count one as to the findings, as a matter of law, there were not sufficient findings with regard to the term fraudulently, and concludes therefore the commission's conclusions as to count one are vacated. As to count two, the court finds there are sufficient findings and the supported by conclusions of law to support the findings in count two. In particular, finding 23, a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Finding that supports that is responded further, eroded the credibility of the judicial system by willfully concealing the truth. Strike that. Responded further, eroded the credibility of the judicial system by concealing the truth from another judge and officer of the court. Respondent failed to truthfully disclose to Judge Mitchell what she had done. She sought to seek an advantage had been created and failed to be impartial in the execution of her responsibilities as an officer of the court. In addition, a judge shall not be swayed by public opinion or fear of criticism. Judge shall not permit family, social, political, financial, or other interests or relationships to influence the judge's judicial conduct or judgment. By allowing her plans to move Raymond Harper into the Otero residence and her frustration with the court process to affect her actions in her own case, she violated 21-204. We turned then to the remedy. Counsel, Ms. Mitchell, Ms. Griffin, I'm sorry. We are conclude unanimously that removal from the bench is not warranted at this time. But we impose the following discipline. We will impose a 90-day suspension in addition to the suspension without pay you've already served. During that time, you are required to have a mentor at the Supreme Court's choosing. That mentor, the names will be provided by the Judicial Standards Commission. You will complete a course of ethics as approved by Judicial Standards Commission. The mentorship shall commence during your 90-day suspension, but continue for a year. You shall complete an Odyssey training as determined by CEI, our Court Education Institute. Within 14 days of today's order, you shall write a letter of apology to each clerk or clerks implicated in your statements regarding imposing the blame on the error upon them and not you. Those letters will be provided to Judicial Standards and then will be provided to us. Yes, the 90 days in addition will be without pay. You may be seated. Thank you. Questions on the order? Any questions from judicial standards on the ruling today?
No, thank you, Chief Justice.
Kenny, any questions on the ruling today? All right, we will reduce this order to writing. I'm sorry, we may in addition write in this matter. And we'll indicate in the order of additional writing is required. With that, the court is in recess.
Court, please.